ఇతరత్ర కోర్టు వ్యవహారాలని కూడా మొదలవబోతుంది. ఇంతవరకు ఏ కేసులో కూడా జైలుకి పంపించలేదు. కానీ ఈ స్కిల్ కేసులో మాత్రం చంద్రబాబు నాయుడు గారిని జైలుకి పంపించారు. అయితే ఇది అన్యాయం, అక్రమం. నన్ను ఎటువంటి తప్పు చేయనప్పటికీ నన్ను జైలుకి పంపించారని చెప్పి చంద్రబాబు నాయుడు గారు ఫస్ట్ ట్రయల్ కోర్టులో అప్లై చేశారు, తర్వాత హైకోర్టులో అప్లై చేశారు, లాస్ట్కి సుప్రీంకోర్టుకి వెళ్ళారు. ఈరోజు సుప్రీంకోర్టులో తుది విచారణ, అంటే ఫైనల్ హీరింగ్ అనమాట. ఈరోజు సుప్రీంకోర్టులో ఫైనల్ హీరింగ్ ఉన్న సమయంలో అసలు సుప్రీంకోర్టులో విచారణ ఎలా జరగబోతుంది, అసలు తీర్పు ఎలా రాబోతుందని చెప్పేసి భారతదేశం మొత్తం కూడా ఎదురు చూడబోతుంది. ఇదొక భారతదేశం మొత్తంలో ఇదొక కీలకమైన తీర్పు అని చెప్పేసి, ఇదొక కీలకమైన కేసు అని చెప్పేసి అందరూ చెప్పుకోవచ్చు. మనతో పాటు లైవ్లో పాల్గొనడానికి సుప్రీంకోర్టు దగ్గర లాయర్లు కూడా ఉన్నారు. వాళ్ళని కూడా కాసేపట్లో లైవ్లోకి తీసుకోబోతున్నాం. దయచేసి ఎదురు చూడండి. జడ్జి గారు ఇంకా రాలేదు, కాసేపట్లో రాబోతున్నారు. ఇవాళ ముఖ్యంగా ఈ కేసులో మా వాదనలు కూడా వినాలని చెప్పేసి ప్రభుత్వం తరపున కేవియట్ పిటిషన్ వేశారు, వాళ్ళు కూడా వెళ్ళారు. అటు సిఐడి తరపున లాయర్లు కూడా వెళ్ళారు. సో కేవియట్ పిటిషన్ ప్రభుత్వం తరపున లాయర్లు ప్లస్ సిఐడి తరపున లాయర్లు, ఇటు ప్రభుత్వం తరపున కేవియట్ పిటిషన్ వేసి రోహత్గి గారు వాదించనున్నారు. మరో గంట సమయం కావాలని అడిగారు గత సోమవారం మంగళవారమే. అలాగే ఇటు సిఐడి తరపున రంజిత్ కుమార్ గారు వాదించనున్నారు. వీళ్ళిద్దరూ అసలు ఏ పాయింట్లు తీసుకొస్తారు, చంద్రబాబు నాయుడు గారిని ఏ విధంగా అరెస్ట్ని వాళ్ళు సమర్థించుకుంటారు అనేది మనకి ఈరోజు వాదనలో అర్థమయ్యే అవకాశాలు అయితే ఎక్కువ ఉన్నాయి. మనకి తెలియని విషయం ఏంటంటే, మనకి చట్టాల గురించి కోర్టుల వ్యవహారాల గురించి తెలియదు కాబట్టి మనకు అన్యాయం జరిగిపోయింది, మనకేదో జరిగిపోయిందని చెప్పేసి మనం అనుకుంటూ ఉంటాం. కానీ మనం కనుక ఈ లైవ్లో కనుక వాదనలు చూసినట్టయితే ఎవరు ఎక్కువ వాదించారు, ఎలా వాదించారు, ఎప్పుడైనా సరే మీరు గుర్తుపెట్టుకోవాల్సిన విషయం ఏంటంటే, కోర్టులో లాయర్లు వాదించిన దాన్ని బట్టే తీర్పులు ఉంటాయండి. కాబట్టి లాయర్లు ఎలా వాదిస్తున్నారు, ఎలా ఉండబోతున్నాయి అనేది మీరు ఒకసారి అర్థం చేసుకున్నట్టయితే బాగుంటుంది. వచ్చారు జడ్జి గారు కూడా రాబోతున్నారు. వాళ్ళ అసిస్టెంట్లు అయితే వచ్చేసారు, బెంచ్ మీదకి వచ్చి సీట్లు వెనకాల ఉన్నారు, మీరు చూడొచ్చు. మీరు దయచేసి ఈ వీడియోని మీరు మీ ఫ్రెండ్స్కి కానివ్వండి, లేదంటే మీ సోషల్ మీడియా ప్లాట్ఫామ్స్లో కానీ షేర్ చేయండి. ఎందుకంటే వాళ్ళు కూడా వచ్చి అసలు ఏం జరిగిపోతుందో ఇక్కడ చూస్తూ ఉంటారు. ప్రజెంట్ జడ్జిలు రాలేదు కాబట్టి వాళ్ళ వాయిస్ అనేది మ్యూట్లో ఉంది. వాళ్ళు వచ్చిన వెంటనే నా వాయిస్ని మ్యూట్ చేసి వాళ్ళ వాయిస్ని నేను ఆన్ చేస్తాను. అలాగే మీకు ఏమైనా అర్థం కాని విషయాలు, కొన్ని ఇంపార్టెంట్ కీ విషయాలు ఉంటే కనుక నేను కనుక మైక్ ఆన్ చేసుకొని మళ్ళీ వాటిని మీకు వివరించే ప్రయత్నం అయితే చేస్తాను. అలాగే మన అడ్వకేట్లు గారు కూడా ఉన్నారు కాబట్టి వాళ్ళని కూడా కాల్లోకి తీసుకొని నేను వాళ్ళతో కూడా మాట్లాడిస్తాను. చూస్తూ ఉండండి. మీకు తెలుగు రాష్ట్రాల్లో ఎక్కడా లేనటువంటి విధంగా మీరు లైవ్లో సుప్రీంకోర్టులో ఏం జరగబోతుందనే విషయాన్ని లైవ్లో మీరు చూడబోతున్నారు మంచోడి మనీ ఛానల్ ద్వారానే. కాబట్టి మీరు ఈ ఛానల్ కూడా ప్లీజ్ దయచేసి సబ్స్క్రైబ్ చేసుకోవాల్సిందిగా నేను కోరుకుంటూ ఉన్నాను. దయచేసి మీరు మీ ఫ్రెండ్స్ కూడా ఈ వీడియోని షేర్ చేయాల్సిందిగా కోరుకుంటున్నామండి. వచ్చారు జస్టిస్లు వచ్చారు. ఇప్పుడు నేను నా వాయిస్ని తగ్గించి వాళ్ళ వాయిస్ని పెంచుతాను.
Item 67 is also there.
Yes.
You have not filed bail in this case?
No, in this case, I'll just tell you. In this case, we had filed the bail in the trial court. Here, that was pending. We said without prejudice to
It is
the 17-day challenge. So that bail has been declined. It's now listed in that matter on the Tuesday on the High Court.
In the High Court.
An application is here. The prayer here was, and I must point out, in 64, the prayer, I'm sorry, the prayer is very specific. We did seek release. Please see my prayer at page number 90.
So you have sought this prayer in 482
Yes.
and you have filed substantive petition
Okay.
before the High Court.
Yes,
for bail.
substantive bail is on other points than 17A. 17A, I'd only come here. My limit, I must point out, I limited my arguments to 17A in the High Court. I have limited my arguments to 17A. So in the item 60, in this, the SLP 12289, I have sought that relief.
Mr. Luthra,
Yes. And
so these are not directly connected, but overall impact would be there.
but that's
So
not the-
we'd like to proceed with this 64 first,
64, my,
and then
I'll leave your lordship with one thought, but why 67 will have some relevance. But in 67, just keep 4 dates in mind. 8th of September, I'm picked up in FIR 29. 64 relates to FIR 24. So in
Here you are asking for anticipatory.
I said your leadership why. I was picked up in the other case, which is the subject matter of 17A challenge, on 8th of September, shown to be arrested on 9th September, JC on 10th September, thereafter PC on 22nd September to 24th September. It got over. They again sought PC, but finally declined, and I'm in JC in that case. So the matter where 17A is under challenge, which you're hearing, that's the position. In the other case, they had on 16th of September sought what is known as a PT warrant, production warrant. That production warrant application has been, there's a direction now to produce me on 16th Monday. So that is the reason. It is in other case.
For interrogation.
For arrest, I assume. So before that happens, I had to move. I went to the High Court, and in fact, in a similar case,
Let's see how this matter proceeds.
I must just point out, in a similar case,
The new
Honorable
matter
High
is
Court passed
completely
that in order.
different.
I just.
Yes,
The anticipatory bail is completely different to the facts of that case. This is another case completely.
Yes, of course.
And Milord, he's already in custody.
No, I'm sorry, not in this case, not in that.
He's not going to come out in any.
Not in
Right,
that.
and I'll pass over the order in a similar case, which is in past.
So what is the matter you are arguing? Arguing the new one.
Right now, I'm on.
No.
Let's
He's trying.
No, I may just,
we are deciding which one to hear first.
just see, in item,
That is on what
I'll
argument.
tell your leadership what's happened is, they are, to put it simply, there used to be a merry-go-round in the circus. We are now in the merry-go-round because they are going with me case after case after case. So there are 3 already. 4th, I'm told maybe somewhere in the offing, but 3 are already there. One is 29 of FIR 29 or 21, where 17A challenge is there. Then there is FIR 16 of 22, where I have this protection order from the High Court. I'll show you the order. Similar.
In the other matter also, you will be challenging this 17A.
In here also 17A is touched. My learned friend, Mr.
So
Agarwal, had argued 17A.
So
17A is there in all cases.
yes, so let the,
The only thing is, but though this is,
which here other matter also,
yes, that's
after this one, of course.
grateful.
Milord, I had on the last occasion.
You were on this Mansoori.
Yes, Mansoori. I had given Milord your lordships the facets of 17A.
The judgments.
Mr. Salve will be joining also in 10 minutes on online. I'm only holding the fort till he comes, and I will not be intervening in the area. My job is only to be a conduit for communication, nothing more. Not to break the rule.
Today the main arguments will be.
Yes,
No,
I,
this is our only.
Yes,
Yes, of course.
So Mr. Dodki, last time we had raised one query.
yes. I've got an answer to that.
Would you like to address
I'll
that?
address that straight away. Your lordship's query was, can you register an FIR today in respect of an offence occurred, say, 5 years ago, under a law which has since been repealed? That was the lordship's query. So, my lord, there is a direct judgment. Your lordship may note, my lord, I brought it. That judgment, my lord, is 2012 8 SCC 669, paragraph 6 and 15. Lord, I have made another compilation, which I have called additional judgment compilation. The first one was compilation. This is additional, my lord. I'll take your lordship straight to that judgment, and then, my lord, we'll go back to Mansoori.
This is paragraph 6.
6 and 15. Kindly see, my lord, page 107 of this new additional compilation. 107. Kindly turn, my lord, to paragraph 6 at page 110 of the compilation. Paragraph 6. The basic submission of Mr. Sharan and Dubey Council is based on the fact,
One,
my lord said, that the 47 Act, that is the PC Act, stood repealed by the PC Act 1988. The alleged crime took place between so and so. The FIR was lodged on so and so, alleging the offences under the PC Act of 47. So, my lord, FIR in 90 in regard to offences under the 47 Act, which was repealed in 88. Exactly, my lord, Mr. Trivedi's query. Council submitted that the FIR could not have been lodged for the offence punishable under the 47 Act, which stood repealed by the new Act. It was urged that, in fact, by reason of receipt, proceedings under the 47 Act stand obliterated. In this connection, attention is drawn so and so. Now, let the finding in para 15 at 114. There is no substance in the contention that the appellants could not have been charged under the provisions of 47 Act after its repeal. As we have noted, the offence is alleged to have been committed prior to the coming into the force of the new Act. When the offence was committed, the 47 Act was in force. It is elementary that no person shall be convicted of any offence except for violation of a law in force at the time of commission of the Act, charged as offence, nor can he be subjected to a penalty greater than what might have been inflicted on the law in force at the time of commission. Article 20 is very clear. The appellants were therefore rightly charged, tried, and convicted under the 47 Act. So, not this.
earlier part probably would go against you.
No? No. Let's see this, Milord.
It is elementary
Yes,
that
That
no person shall
be convicted of an offence. This is a part of Article 20, Milord. Shall be convicted of any offence except for violation of a law in force at the time of commission of the Act. Now, pause here, Milord. Just stop here. In our case, Milord, the period of offence is 2015-16, at which time 13(1) C and D were in operation, if you also would recall.
Let us see under which provisions the FIR was registered in.
In this case, my lord, it was registered under the 47 Act. In this case, 47 Act was repealed by the new Act, which is the current PC Act. Let's come back to 6. Come back to para 6. Para 6. The basic submission of Sharan and Dubey for the appellant is based on the fact that the 47 Act was repealed by the 88 Act. The alleged crime took place between such and such period. FIR was lodged in 1990, but not relating to offence under the 47 Act, which had since been repealed. So FIR lodged today in respect of not a past offence, which was an offence then, but which has been repealed later. Council submitted that FIR could not have been lodged for offences punishable under the 47 Act, which was repealed by the new Act. In my case, my lord, 13 C and D have since been omitted by the amendment of 2018. But he is charged in 2015 when C and D were alive. He is charged today for offences of 13(1) C and D at a time when the C and D was alive on the statute book. Therefore, the argument raised here was that today you cannot lodge an FIR in respect of an offence under the old Act, at which time 13(1) C or D in my case or under the 47 Act were available. So it was urged that in fact, by the reason of repeal, proceedings of 48, 47 stand obliterated. Now come back to para 15. Page 114. There is no substance in the contention that the appellants could not have been charged under the 47 Act after its repeal. Pause here, Milord. 47 was repealed in 88. FIR is in 1990, but relatable to offences under the 47 Act. Sorry.
Excuse me,
Yes.
just read para 14, last part.
14. Yes.
If the repealing act discloses a different intention, the repeal.
Correct.
shall
Absolutely right.
result in situations stated in.
Yes. You're saying right.
Intention is disclosed in the provision of the. That repeal act.
So if there is a different intention, let me explain. I've understood the query.
Investigating agency.
No, I understood the query and I'll answer it. So, my lord, when repeals happen, generally, under Section 6 of the General Clauses Act itself, usually when repeal happens, it happens like this, my lord. In 2018, some part of the old law is gone. That's how the repeal is. So, the old law will survive for offences relatable to that period, notwithstanding the repeal. That is the law. Unless there is a different intention, which means that if the legislature wishes to make its position clear today, that not only have we repealed two provisions, we are saying that today those repeal provisions shall not be applicable at all. That is the different intention. For example, I'll show you, Lord, FEMA. That's the answer. Just have a look at FEMA.
Let us take a simple case of 377.
Yes.
377, to an extent, the Constitution bench has struck down.
Stuck it down.
Can you register an FIR under 377
That
on the ground that the offence has taken place 1 year prior?
That position is different.
Fine.
When your lordships will not declare a provision unconstitutional, it will always be deemed to be unconstitutional from the day it was born. So that's a different regime. This is a different regime. And there also, your lordships only have the power, no High Court has the power, for declaring unconstitutionality prospectively. So that is a different regime. It is erasing it from the statute book as if it never existed. So that's not the regime here. Here, give your lordship an example of different intention. Have a look at FEMA. That will give your lordship the answer. Kindly, my lord, see here, section 49, the repeal. When it repealed FERA. Kindly turn to 49. Now, first see 49.1. FERA 1973 is hereby repealed and the board constituted thereunder is dissolved. Now see 3, my lord. Notwithstanding anything contained in any other law for the time being in force, no court shall take cognizance of an offence under the repealed act. This is the different intention. Otherwise, mere repeal does not efface the offence existing prior to the repeal. That is section 6. I'm just reading it. Now see 3. Notwithstanding anything contained in the law time being in force, no court shall take cognizance of an offence under the repealed act, and no adjudicating officer shall take notice of any contravention under the repealed act after 2 years from date of commencement. This is different intention. That look, normally repeal is governed by section 6. Normal repeal today will not prevent the authority from acting under the repealed law if the offence was at the time when it was alive. But if there is a different intention, as is expressed here, no court shall take cognizance, no IO shall take cognizance after 2 years. This is called the sunset clause. So for 2 years, the old one will apply, but after the sunset of 2 years, it will come to an end. It could have been even without sunset. It can be without sunset. Then on the repeal today, Parliament tells you that repeal means that all proceedings under the old act will also abate. So Parliament has power to say old will abate. Repeal will not be fully effective because of this. These are different intentions. And, my lord, the answer to your lordship's query, which is a very important query on unconstitutionality, by a declaration by the court, the law is that when your lordship declares something unconstitutional, it is deemed to be from the day when it came on the statute book, namely 1860,
Void.
under IPC, unless even your lordships have, my lord, a caveat, unless your lordships, my lord, make it prospective, which is a rare phenomenon, but is used by the court in rare circumstances in order, my lord, where public interest overwhelmingly demands to make it prospective. Your lordships have said that prospectivity can only be, my lord, by a declaration by the Supreme Court and not by the High Court. But that, my lord, this is not the central position I can give judgment.
What could be the rationale of that? 142.
Yes, that the power is only because, my lord, normally, my lord, when a lordship declares the law, the High Court declares it's gone from inception. It's void. Many judgments here.
No, judgments are there.
That power because of 142.
What
It's actually 142.
provision it was anchored?
There is no provision. It's 142. It's 142. Because ultimately your lordships balance the ends of justice to reach out, my lord, where suppose, my lord, chaos will happen if you strike down, my lord, something which has been there for years. People's, my lord, have not been able to put their affairs in order. What happens? So if it is going to be a mass chaos, then and then only in rare circumstances, the Supreme Court alone has the power to make it prospective. But that's a different law, we are not concerned. So this is the answer, my lord, to your lordship's query in regard to an FIR today in respect of a repealed law. Now we go back to Mansoori, my lord. Mansoori, my lord, is in the old compilation. My lord, your lordship may note on this proposition that law will always be deemed to be void. This is the latest judgment, my lord, of the Constitution Bench. Your lordship might note these. When, my lord, 6A was declared, your lordship may note, my lord, 2023 SCC online SC 1146
Just 1 minute. 2023.
23 SCC online SC 1146. So, my lord, this judgment is only to decide that when the 6A was declared unconstitutional under this act in Subramaniam Swamy, my lordship recall there was a provision, my lord, which said that, my lord, protection, my lord, under 6A will only be given to deputy secretaries and above.
Joint Secretary
It was challenged, my lord, by Swamy,
on the ground.
saying that, my lord, high ranking officers get, my lord, the coverage and protection. But what about that? If there's a crime, there's corruption, there's corruption.
On the ground of violation of Article 14.
My lord, you can't create a distinction of high level and low level. So 6A was struck down. A question arose which your lordships are asking today. Will it be from day one or will it be from some other day?
That has been answered by.
That has now been answered by a new constitutional bench only for that purpose, my lord, which is this time. That is it. Your lordship may only note, my lord, and they say that when we declare it void, it is void from the time that it is stillborn or was never there. So we don't need to, my lord, get involved in this. Now, so Mansoori, my lord, was for the proposition.
Just 1 minute.
Yes. Mansoori is in the old, my lord, compilation.
Yes, 264.
My lord, I was only showing, my lord, before I read it. The proposition is that 17A or 6A has that provision, my lord, a decision or recommendation in the official discharge of public duty. You lordship remember that phrase. It's not an absolute bar like 197 or 19. 19 is an absolute bar. Our bar is, if it applies,
When in a position to recommend
recommend or a decision taken or a determination in the exercise, my lord, of his public office. That's how it is. Whether that can be decided today at the stage, my lord, where investigation is yet to take place. 1 month has passed, and is 482 an appropriate court to decide whether it is discharged or not discharged? I am saying, my lord, corruption can never be, my lord, in discharge of duty. He says, no, it can be. This is a question of fact. This question of fact cannot be determined unless parties are ad idem on the question, my lord, that it was in discharge of duty. Therefore, in Mansoori, my lord, your lordship will first find. See, my lord, in Mansoori, your lordship will find kindly, my lord, see paragraph 15. This is an example to show.
But Mr. Rohatgi, we are having little, we followed the
Yes.
logic of your argument,
Yes.
but we are having a little doubt about how this would be implemented.
My lord,
Because,
Yeah.
see, the bar is on starting any inquiry.
so the yes, I've understood. I've understood.
Will the police officer have to form an opinion
Yeah.
that
So, my lord,
record it somewhere and then start?
so, my lord, if
The approving authority would not have any material with it.
so, my lord,
So on what basis does authority give
so
the,
authority will have to see whether the allegations contained can remotely, my lord, be connected to a recommendation or a decision in the discharge of public duty.
But point is, see, this is an entry point bar, unlike
Yes.
197.
Yes.
It's a bar like that Judges
Yes,
Protection
entry-
Act, Section
entry
6.
point, Yes.
So if it's an entry point bar, then the person who is starting the inquiry,
Yeah.
how will
He
it
will, my lord, make it.
decide whether it
He will decide on the basis of, my lord, the material available to him. Suppose, as I said, let's take it further.
because it's not only also investigation,
I understand.
inquiry and inquiry.
So it is prior. It is
Yes.
prior. So, my lord, he will have to take a call. What your lordships have said repeatedly, that, my lord, allegations of corruption can never be a part of official duty. How does he decide? So, if the allegations are such, I'm giving an example, my lord, strange, extreme example. Suppose some officer, my lord, puts his hand in the till and withdraws, my lord, 1 crore from a cash box and goes home, and he is caught later, not on the trap there, but caught later. And this fact is presented to the officer. He will form an opinion that this can never be a part, my lord, of a recommendation. That's what the phrase is used by Parliament. How to do it, my lord? There's no other way. And repeatedly, your lordships have held that in cases of corruption or cases where the actions are, my lord, outrageous, it can never, my lord, be decided by that fellow that this bar will apply.
Going by the direction you were attributing to this,
Yes.
the investigating officer of CBI or whichever
Whichever.
agency, while writing the
Yes,
general diary,
Yes.
will also have to record.
Yes, he will record.
Position of
Yes,
official.
my lord, he will have to record. Yes, because he is faced with a provision. And the provision applies only if it is a bona fide decision or determination in the exercise of official duty. But if the facts show to the contrary,
no, where are you reading bona fide?
no, my lord, he will decide. In a bona fide, my lord, he will decide whether,
But he hasn't started the inquiry also.
but my lord,
How will he know?
so my lord, he has to have some,
Trying to figure out the workability of this
my
provision.
lord, somebody has challenged 17A also in this court. In-
But now the question would be whether 17A would be applicable in this case, because
yes.
according to you, the FIR is registered under
Now.
offense under the old act.
Correct.
As
Registered now, but relatable to old act.
17A would be applicable.
No, it won't be applicable.
Offenses of now.
Of simple, I told your lordship 2 packages. One package is prior to July 18. The second package is post July 18 after the amendment. If the offense, notwithstanding it is registered today, if the offense relates to the past package when C and D was aligned, there was no 17A, therefore 17A can't apply. That was my principal argument. Thus, and it has been so held by 4 high courts. It's not my argument alone.
So if we are with you
Then-
on that,
Yes.
the other questions would not arise.
So this is one. Then I have 3-4 my lord arrows in my bow. This is one. Second, I'll put my arrows, my lord, so that
Yes.
your lordship can know.
Better.
First is that 17A does not apply to an offense which occurred prior to 17A being born. Simple. 17A is born, my lord, in July 18. The offences are of 2015-16. On that day, he can be tried only by prevailing law. No benefit of 17A can be given in 2015-16 because it was not on the statute book. Number one. Number two, alternatively, the allegations, my lord, in the FIR, which are being investigated, prima facie according to the FIR, which has to be accepted today, my lord, in a 482. Prima facie, my lord, the allegations are such that they can never be remotely considered to be a decision or determination or recommendation in the exercise, my lord, of public office. And I will show you cases of the first proposition that 17A can't apply to the past. There are cases already. And the proposition, my lord, that if it is the case of misappropriation, etc., then neither 19 nor, my lord, this 17A, nor 197, in whichever avatar they appear, neither 197 nor 19. 19 is a stricter bar. 19 doesn't have this phrase, my lord, of recommendation and public office. It's an absolute bar. The lordships have said neither sanction of 19 nor, my lord, of this 6A, 197, whatever, can be a obstacle or a stultifying, my lord, stultifying it cannot have a stultifying effect. And if at all this is to be debated, it will be debated when the facts are found by the judge. And the facts can only be found by the judge because there is a difference of perceptions between the accused and the prosecution.
One 197 also talks about cognizance of the court.
Yes.
It doesn't talk about.
I follow.
Inquiry.
I follow. But not
investigation.
whenever there is a dispute on 197 or 19.
We are not on 197 or
All right.
19.
Yeah.
It's only.
Correct. I'm only saying, my lord, this phrase. See, 17A has put a phrase. 17A could have been like 19, my lord. 17A could have been an absolute bar like 19. It could be. But why did Parliament insert that phrase? Because please remember, my lord, I respectfully submit. We are dealing with a law on corruption. This is not, my lord, an act called Protection of Public Servants Act. This is not an act like that. It is the law of corruption. In corruption, you already have 19. You already have 19. One modicum of protection is given to honest.
ఇప్పుడు ఏం జరిగిందంటే అండి, ఇక్కడ జస్టిస్ బోస్ గారు అడిగారు, అతను ఇంకా విచారణ ప్రారంభించలేదు, అతనికి ఎలా తెలుస్తుంది అసలు? దయచేసి ఆ విచారణ యొక్క సామర్థ్యం ఏంటి, సదుపాయాలు ఏంటి అని చెప్పేసి అడిగారు. అప్పుడు జస్టిస్ త్రివేది గారు అడిగారు, ఇప్పుడు ప్రశ్న ఏంటంటే అసలు ఇక్కడ సెక్షన్ 17A అనేది వర్తిస్తుందా వర్తించదా అనేది జస్టిస్ త్రివేది గారు క్వశ్చన్ చేశారు. ఎవరిని? రోహత్గి గారిని. రోహత్గి గారు ఏమంటున్నారంటే, లేదండి ఇది వర్తించదు అంటున్నారు. ఎందుకు వర్తించదు అనే దాని మీద ఇప్పుడు అతను మాట్లాడుతున్నారు. చూద్దాం ఏం మాట్లాడుతున్నారు చూద్దాం.
That if there is a dispute, the benefit would go to the prosecution. It's absolutely topsy-turvy. Because you have to get rid of corruption. That is the object of corruption. That is the object, that is the object of the act. So in the case of, my lord, a doubt, it will go the other way. I'll show that, your lordship. That is also, my lord, I think Swami's case. Swami's case. Yes, I'll show that. But I am now, my lord, in Mansoori showing your lordship an example where this court said that a particular act in a given case can never be, my lord, a part of official duty. Correct. Kindly turn to paragraph 15. Milord, I'll show Shambhu again, but just turn to paragraph 15 at page 268. And what is the stage to determine this issue? Is it a 482 within 1 month, where Milord investigation is got to be scuttled? See paragraph 15. Going by the assertions in the complaint filed by the appellant, prima facie it appears that without authority, the first respondent with other officers entered the house of the appellant and committed.
ఎంసీ గుప్తా అనే వ్యక్తి 2012లో ఒక కేసుని కోట్ చేశారంటండి. ఇతను 2012 గురించి కేసు గురించి మాట్లాడుతున్నారు, కానీ 2018 తర్వాత ఈ సెక్షన్ 17A మార్పులు చేర్పులు జరిగినాయి, దాని గురించి మాట్లాడతలేదు. చూద్దాం ఏం జరుగుతుంది.
We cannot conclude that sanction was required because there was no sanction here. 197 says you can't move without sanction. No sanction is required. In the facts, the final view can be taken only after evidence is recorded. Therefore, my lord, you cannot nip it in the bud in 482. You can't decide this question in 482 unless parties are agreed. As I said, my lord, there is a recommendation or a decision. Therefore, even on 197, which is an absolute bar, my lord, and doesn't have the words of 17A, this court has taken the view that 482 is not an appropriate stage to decide a question of fact which can only be decided by trial. That is one. Lord, I showed on this Shambhu's case. I want to show it again. After this, Lord, I will proceed further. Shambhu, Lord, is in the same compilation. Kindly turn back, Lord, to 150. Judgment starts, Lord, from 148. Kindly turn straight to paragraph 5 at 150. I had read it, Lord. I just want to read it again so that we close this chapter.
నేరం చేసిన తర్వాత ఈ సెక్షన్లు అనేవి మార్చబడినవి కాబట్టి ఆ పాత సెక్షన్లు అనేవి వర్తిస్తాయి అనేది ఈ రోహత్కి వాదనలండి. దానికి సంబంధించి గతంలో ఎంసీ గుప్తా అనే కేసును ఒకటి కోట్ చేశారు. అయితే మన వాళ్ళు ఏమంటున్నారంటే అమెండ్మెంట్ యాక్ట్ ప్రకారం 2018లో మారింది కాబట్టి దీని ప్రకారం సెక్షన్ ఏ వర్తిస్తుందని చెప్పేసి మన వాళ్ళు వాదిస్తున్నారు. వాదించదని చెప్పేసి వాళ్ళు వాదిస్తున్నారు. చూద్దాం ఏం జరుగుతుందో.
This can't be decided.
17A.
On 17A. On 17A, my lord. I have three arguments. One, 17A, my lord, will not apply to past offences, even though registered today. Two, that 17A on a question of fact, whether it is a decision in the exercise of public duty, etc., my lord, is not a question which can be decided in 482. And the third argument is, my lord, that, so another alternate argument is that, my lord, the inquiry under 17A started, my lord, in June 18. Lordship, remember that?
Yes.
5th June. So three arguments. Not under 17A, inquiry had commenced in June 18 because there was no 17A then. Therefore, inquiry had commenced as a question of fact. These are three separate submissions, my lord, which I have on 17A. And the fourth submission is, my lord, that 17A occurs, my lord, in the Prevention of Corruption Act. It cannot be read in isolation to provide, my lord, an umbrella of protection. It is not an umbrella of protection. It is only, my lord, wherever applicable, a step. It's a step in aid for, my lord, the prosecution to look at it and then proceed. That's it. It is not a protection. And it is within the contours, my lord, of Prevention of Corruption Act. You have to, my lord, when you interpret 17A, my lord, you will see the object of the Prevention of Corruption Act. And then construe 17A, not beholds, my lord, the object.
No, therefore I.
Yes, your lordship is right.
But there is no mention of.
Doesn't matter.
The object.
But I will show you, my lord, judgments of the Supreme Court that on issues of corruption, if there is a doubt, you will go in.
రోహత్గి గారు ఆర్ఆర్ కిషోర్ 2023 గురించి ప్రస్తావించారండి. ఈ సందర్భంలో సెక్షన్ 6A శూన్యమైనదిగా ప్రకటించినప్పుడు అది ప్రారంభ తేదీ నుంచి శూన్యంగా పరిగణించబడుతుంది అని కోర్టు ద్వారా చెబుతుంది అని చెప్పేసి ఒక కేసుని అయితే కోర్టు చేశారండి. సెక్షన్ 6A గురించి కూడా దీంట్లో మాట్లాడారు. అంటే నేరం జరిగిన తర్వాత మార్చబడిన చట్టాలు నేరం జరిగినప్పటికీ వర్తిస్తే వర్తించడం అనేది ఇక్కడ ముఖ్యంగా కేసులో అయితే విచారణ జరుగుతుంది. అంటే సామాన్యులకి ఇది గౌకును అర్థం చేసుకోవడం కష్టం కాబట్టి కొంచెం వెయిట్ చేయండి. ఇది కేసు కొంచెం క్రిటికల్గా మారే అవకాశాలు అయితే కనిపిస్తున్నాయి. ఏం జరుగుతుంది అంటే కొంచెం వెయిట్ చూద్దాం.
The largest number of judgments and orders. If you combine,
వాదిస్తున్నారు ఆన్లైన్ కేసు కోర్టు చేస్తున్నారు, ఆన్లైన్ కేసు కోర్టు చేస్తున్నారని చూద్దాం.
done it. Paragraph 5 at page 150. The question is very important. When the public servant is alleged to have committed an offence of fabrication of record or misappropriation of public funds, this is my case. Can he be said to have acted in the discharge of official duties? It is not the official duty of a person to fabricate false records or misappropriate furtherance of discharge. Official capacity enables him to fabricate the record, does not mean that it is integrally connected or inseparably linked with the crime, as was believed by the judge. Under these circumstances, we have the view that the High Court and the trial court are clearly wrong, cannot be sustained. So, my lord, as I said, the only caveat is when parties are agreed that a decision is taken in the exercise, my lord, of public duty, except that there is no way that this question can be, my lord, determined in 482. Simple. I stop at that. How do you determine in a 482 within, my lord, 10 days or 5 days, my lord, of the investigation commencing? That's going to be my last argument ultimately. That you are wanting to scuttle everything. You are arrested today, tomorrow you file, my lord, a 482. I've never seen a 482 being filed on the second day. And
ఇప్పుడు రోహత్గి గారు ఏమంటున్నారంటే 2018లో ఈ సెక్షన్ 17A అనేది మార్పులు చేర్పులు గురవడానికి ముందే విచారణ ప్రారంభమైంది అని అంటున్నారు. ఆ విచారణ ప్రారంభమైంది అనడానికి కనుక వాళ్ళు కనుక ఆధారాలు సమర్పించినట్టయితే కేసు కనుక సిఐడి వారికి లేదంటే ప్రభుత్వం తరఫున ఎక్కువ అవకాశాలు ఉంటుంది. మనకి కొంచెం బ్యాడ్ న్యూస్ వచ్చే అవకాశాలు ఎక్కువ ఉన్నాయి. చూద్దాం అన్న.
if it's a simple case of no offense, you'll also quash an FIR. But if, my lord, a prima facie case made in the FIR, there is no way that the court will scuttle the investigation. I will ultimately show you, Lordship, Lord Justice M.R. Shah's judgment in Niharika. That, my lord, comprises of everything, but we'll come to that later. So this is, my lord, this position. Now, my lord, there is one more judgment which I wanted, which I have not shown as yet. That is, my lord, 122. This says, my lord, this is Kerala. Your lordship may note, my lord, out 122. This says that 17A will not apply prior to it was born. Simple. I'm putting it in one line. 17A will not apply to offences relatable to a period before 17A was born. And this is not the only High Court judgment. There are several High Courts who have taken the view that 17A, my lord, cannot apply to a position anterior.
Any different view taken by any other?
No, I don't have, no. There are 3-4 views. This refers to a Delhi view also. And SLP against this, my lord, was dismissed by Lordship's Justice.
We've given the different views of the High Court in the combination
that.
of court.
It's also
So those sets of
clear.
views
I had that impression, but.
we have given it, leadership. We've given it,
All right.
given that.
But anyway, this came to.
Different view also.
There are two
No,
sets
I didn't have it.
given them.
You may have it.
So we tentatively supplied to public.
No problem. This has come to the Supreme Court. Justice Trivedi sitting with Justice Khanna passed a short order which I'll show to you. Now we will have a look at 122. Sorry, Lord, this is on actually on 17A, the interpretation of 17A. Kindly turn straight to para 18 at 129.
The Kerala.
Not para, para 18 at 129. I made a mistake, Lord. This is only for the interpretation of 17A. This is on scope. Now see para 18. I am reading it this, Lord, on the assumption, if your lordships hold it applies, then what happens to, Lord, those words, recommendation or decision, para 18. 17A has to be analyzed in the background. The most crucial part provides previous required in case of inquiry, investigation, any offence alleged to have been committed under the Act, where the alleged offence is relatable to any recommendation made or decision taken. It seems that the above part of the section is the most crucial part, since it imposes the rider on the otherwise absolute power that inquiry into every act needed prior approval. It is clear that not every offence alleged to have been committed under the Act needs prior approval. Approval is required only.
చాలామంది మన ఛానల్ సబ్స్క్రైబ్ చేయలేదండి. ఇలాంటి మరిన్ని న్యూస్ ఫాస్టెస్ట్గా కనుక మీరు కనుక లైవ్లో ఎక్స్పీరియన్స్ చేయాలనుకుంటే మన ఛానల్ని సబ్స్క్రైబ్ చేయండి, లైక్ చేయండి, మరియు మీ ఫ్రెండ్ లిస్ట్లో ఉన్న వాళ్ళకు కూడా షేర్ చేయండి. థ్యాంక్ యూ.
The Parliament constitutionally used the above word if the intention was to impose a precondition that every inquiry is clear, every allegation against the public service requires prior sanction. The words where the alleged offence is relatable to any recommendation made in decision ought not to have been there. If the above words are omitted, it would have meant that no police officer will conduct an inquiry into alleged offence alleged to have been committed in the Act in discharge of his duty without the previous approval. In other words, if the intention of the statute is to cover every inquiry in this, the words where alleged offence is related to the recommendation made or decision taken were unnecessary, etc., etc. Now, 19. This seems to be in parameter 197, also including the scope of law, various decisions while discussing the scope of 197, etc. Kindly turn the next page. Kindly, my lord, see 6-7 lines from top. The lordship will get a sentence, my lord, starting on the right side of the page. It could not be expected. But let's get that line. My lord, above para 21, 5, 6, 7 lines on top. Sentence starting at 131. Sentence starting, it could not be expected. It could not be expected that Parliament wanted to impose spokes at 3 different levels. Look at this plot. 1 under 17A, 1 under 197, and 1 under 19, and thereby paralyzing every investigation, inquiry against the public servant. Such an interpretation will defeat the purpose and object of the statute, namely Prevention of Corruption Act, which is intended to weed out corruption. The object of the PC Act to protect honest and upright officers and to ensure that they are not unnecessarily dragged in litigation is also intended to ensure that officers are insulated and protected against unnecessary litigation. Such a protection enables officers to take prompt and bold decision files and the administrative machine move forward. Otherwise, the officer will be reluctant to make official recommendation or take any decision apprehending a false accusation. In this context, as you noted, the scope of 70 is confined to, again, quote, any recommendation or decision taken by the servant which alone falls within the protection of the servant. Definitely, cases, please again mark, cases of offences like misappropriation of funds, fraud, falsification of account, criminal breach of trust conspiracy cannot be covered by the protection of 17A, which means not at the threshold, at the entry bar, as the lords put it. Definitely, they do not involve any decision. Such acts cannot be considered as one in charge of official functions, and hence cannot be by any stretch of imagination be held in investigation anything as mentioned. Need prior approval. So they will not need prior approval. Such an interpretation, etc., etc. Then, Milord, they refer to a Delhi judgment in para 22. I am not reading that, Milord. That is a Delhi judgment which has taken the same view, and that is reflected in para 23. Para 23. So 23 and then 24 minutes. See 24 minutes, last 5 lines. I am of the firm opinion that in cases in hand which involve allegations of falsification, breach, and misappropriation, which are expressly criminal, no prior approval, etc. Well, therefore petitions are dismissed. Now this came to your lordship's lord. And your lordship's order is at 310. $310. Turn to 310. But the first para is the same argument, which is the query which Justice Trivedi had raised below. Learned Counsel states that 13.1 was amended or substituted with effect from July 18, and 13.1D was not in the statute when the FIR was registered. Same argument. But the real beloved part is the next page. The impugned order has primarily examined the purport and effect of 17A, keeping in view the factual background. We are not inclined to interfere, but leave it open to the petitioner to raise the contention before the IO or the court. Why? Because this dispute, is it a part of official duty? Is it not a part of official duty? So this is, my lord, this is not an SLP, my lord, dismissed in limine. It is dismissed, my lord, with a speaking order. That, in other words, if I paraphrase this order, my lord, it means do not do it at 482. You will have a chance, my lord, when evidence is thrashed out or when some facts are thrashed out. That is what, my lord, this means. Now, my lord, one more important thing I wish to show. My lord, kindly take up. I am on a, this part is over now. I am on a separate proposition, my lord. The petitioner, my lord, in the SLP says that I have nothing to do with the decision. My lord, he says, I have nothing to do with this decision for forming, my lord, the skill board. If you have nothing to do with this decision, how are you talking about 17A? They are mutually contradictory. Kindly turn to the SLP, my lord, page 82. Page 82, ground U. Page 82, ground U.
Now, it can be argued
Yes,
that it is the petitioner's stand that he hasn't,
right,
he wasn't involved in that
right,
process.
correct.
But what the prosecution is alleging that
No,
he did it at the,
no, I am not arguing that. No, I am saying that if the petitioner says that I have nothing to do with the decision by which the skill council was cooperation was made, etc., etc. If he has nothing to do with it, then how can he talk about 17A at the same breath and say this is an exercise of official duty? You say I have nothing to do with it. If nothing to do with it, then 17A doesn't apply in any case. 17A applies only when the public servant says, yes, I did it in the course of official duty and I am protected. Your Lordship may now see page 82. So his stand at page 82 is mutually, my lord, destructive of his plea that 17A can never apply. Turn to page 82. Paragraph U. See, my lord, that the petitioner may I read that. That the petitioner was neither the minister in charge nor had anything to do with the corporation during the period of the alleged offence,
నాకు
and
అర్థమైంది
perusal of
ఏంటంటే
the material does not make out a case against the commission. That's all
న్యాయ
right.
వ్యవస్థలో
I'm on the
చాలా
first line, first 3 lines. If you
లొసుగులు
had
ఉన్నాయి.
nothing to do with the corporation,
వాటిని ఉపయోగించుకొని వీళ్ళు కేసును
then
వాదిస్తారని
your
చెప్పి నాకు
stand
అర్థమవుతా
is,
ఉంది.
my lord, that you are not a public servant concerned with a decision in the discharge of your duties, because you say I am not concerned. If I am not concerned, then 17A cannot apply. Now, my lord, the alternative argument was that an inquiry had in any case commenced. I only want to just your lordship to see two documents. It had commenced when the petitioner was the chief minister, and it had commenced in regard to this very issue. The other side is completely wrong in saying that the inquiry which had commenced in 2018 June was in relation to something else. No, it was very much in relation to this very case or these very facts. That, my lord, will be clear from two documents. Your lordship may note. The two documents are, my lord, communication dated 5/6/18. I just showed you, Your lordship. Your lordship may note, my lord, the fact that inquiry had commenced in this very issue is evident from two documents. Your lordship may note the documents, and I will, my lord, give the pages. 5/6/18, which is volume 5, page 2, and the anterior document, which is 14/5/18, which is, my lord, volume 4A, capital, at page 811. And before I show it, your lordship may note that these documents were given in a memo by the additional AG to the judge during the hearing. It was argued thereupon. The learned judge has, my lord, accepted the argument on pages 23 and 33 of the order under appeal. It was given, argued, emphasized. The learned judge, my lord, has accepted the argument at pages 23 and 33, 22 and 33. And as I said, it was reserved on the 19th, when all of us argued till 5:30 in the evening. And on 20th, it was reserved on 19th, memo given across the bar. And on 20th, my lord, the memo was formally filed in the registry. Those are the facts, my lord, of this. Now, your lordship, have a look at the document. Your lordship will find kindly see, my lord, volume 5. It's a very slim volume, yes. Now, see, my lord, this is at the time when he was at the helm of affairs, and these are not, my lord, private documents. They are documents, my lord, of the concerned departments. Kindly see, my lord, Office of Director General ACB, Andhra Pradesh, Vijayawada, 5th of June 2018, memorandum. Now see the subject, my lord. Public Servant, Industries Department. My lords have that. Allegation of corruption against officials of AP State Skill Development Corporation. The entire case is of Skill Development Corporation here. Now, it was not, my lord, on that day clear that it was the Chief Minister himself. Now see, my lord, regular inquiry ordered. Now see reference. My lord, your lordship will find after the name Sri, it is cut out. Lordship sees that? That is because he was a whistleblower, my lord. He said, don't show my name. Letter of, I'm reading whistleblower, dated 14th May 18, which is, my lord, less than a 1 minute. Which is, my lord, less than a month before. Now see second. CBI's letter of 2017, dated 27/10/17. So it appears, my lord, that this Mr. Whistleblower wrote to the CBI, wrote to the department, and the CBI forwarded it to us also.
Is that Whistleblowers Protection Act operable now?
Yes, it is operable. It is operable. It is operable, but my lord, I don't know in what measure, but it is operable. I just came across a case the other day.
Has it been
Yes.
implemented or no?
It is implemented in parts, not some of it happened in that Godhra cases, etc. But I recently came across a case, my lord, where
దయచేసి వీడియో చూస్తున్న వాళ్ళందరూ కూడా లైక్ చేసి కామెంట్ చేసి మీ ఫ్రెండ్ లిస్ట్లో ఉన్న వాళ్ళందరూ కూడా షేర్ చేయాల్సిందిగా కోరుకుంటున్నామండి.
those names for those reasons. And I'm sure, my lord, then
In Bhota and Tara cases also, names are kept blank.
are cut blank.
They are given A1, A2.
A1, A2.
P2.
Here PW was given blank.
In those legislations, if I may add, in those legislations, there is a provision made for masking the identity, and those are secret witnesses. By the NIA, there is a provision UAPA, Bacoca, and Tata and Put.
Protected witness.
Protected witnesses not protected, and therefore IPR is the special prosecutor.
All right. Now, my lord, your lordship
to
find,
enact this names and identity.
your lordship will find the substance, letter of so and so and letter of CBI, Pune are enclosed. You are instructed to conduct a regular inquiry into the contents of the letter petition and submit a report within stipulated time. You are also directed to submit plan of action duly approved by the LA, come special PP, ACD, etc. On the left, your lordship will find copy to one Mr. Venkatesh Rao, DSP, etc. On the next page, my lord, your lordship will get. No. So now pause here for a second. Or my lord, your lordship will see further. Further, my lord, what happened? These are all letters in furtherance of this. The next, this letter again refers, my lord, see reference 5th of June in the reference on the next page, if my lord sees. He talks about the earlier one. With reference to the above, the Bureau is investigating regular inquiry pertaining to allegation of corruption, misappropriation funds, and procedural lapses in the subject. In this regard, we request you to provide information and attested copies, etc. Previous letter of so-and-so. Turn to the next page. See again reference, 5th of June 18. With reference, Bureau is investigating regular inquiry pertaining to allegation of corruption, misappropriation funds, procedural. In this regard, you request to provide information through letters of 2021. So it's going slow, but it was going on. We have not received communication from your end, but we once again request you to provide. Next page. Again, my lord, reference is 5th of June. It is informed that Bureau is conducting regular inquiry. So it goes on and on. Lord, page 6, page 7, etc. All that is going on. So it's not something that it just started and like a whimper it ended. All this is going on. And I was showing to you, Lord Shimrat, the other letter of 14th May, which was prior to 14th May. Because 5th of June is referred to him, refers to 14th May. I just want your lordship. I've shown to your lordship what happened till 21. 14th May, my lord, is in volume 4A. Kindly see for a second. Volume 4A, page 811. This was, my lord, the whistleblower's letter.
Page
811. This is the precursor of 5th June. This is the precursor of 5th June.
page 11.
811 below. 811. This is the whistleblower's letter. Sir, this information is being given by private capacity. I request protection under the whistleblower's. Now, let's see subject. Submission of information regarding corruption having government funds by AP Skill Development Corporation, so and so public servant with the help of private entities, amount involved 330 crores. Please refer to letter so and so when complaint was given by me at Pune have been forwarded to your office of information. In this case, I am giving further evidence. In this case, can be seen that the officers of the corporation public servants have also given information to the DG Central Excise. Their investigation points out the involvement of government officers at various levels. Investigation by them is available in incident reports issued by them. Copies include incident, etc. From the incidents, it can be seen that following companies are involved. So the names of those companies are involved below where there's an agreement between them and the Skill Development Corporation. On the next page, it can be seen that it can be seen that the majority of the companies are defunct, or the companies were issuing invoices without providing any service. Companies have admitted that they received consideration from Skill without providing service. This consideration was again routed to some other companies as per instruction. it is mentioned that these activities were done under the instructions of one company called Messrs. Design Tech and Siemens. These are those two companies, my lord, which purportedly had a tie-up where money was diverted. Director General GST has dealt with service tax part. I request you to take up the corruption part. As the officers of the corporation and public servants, it can be seen that though no service is received, yet they are not pointing out or doing nothing to recover money is given to design tech. This clearly points to involvement of the corporation in siphoning 330 crores of government money through the above private agencies. This is corruption on the part of officers and employees of the corporation for which action needs to be taken. Your office is jurisdiction. Investigation needs to be done at the APS with the mechanism criteria, so and so. It is clear that many loopholes, etc., if without receipt of service, that they are certifying services received, etc., etc. So it is on this, my lord, that this. Now, my lord, I wish your lordship to see that Swami's judgment, which says, my lord, then, my lord, your lordship may know on the construction of the PC Act. How do you construe the PC Act? 2012, your lordship may note, for construction of the PC Act, 2012, 3 SCC 64, paragraph 18, which your lordship will find in the original compilation at page 161 of the book. 161.
No,
161.
Swami,
Subramanian Swami.
that is against Director Central Bureau of Investigation.
No, that's another one. We have to turn to page 161. Your lordship may look at the old volume,
Yes, yes.
not the new volume, the old volume. Page 161. Kindly turn, Millard, to page 194. Today, corruption in our country not only poses a great danger to the concept of constitutional governance, it also threatens the very foundation of the democracy and rule of law. The magnitude of corruption in public life is incompatible with the concept of a socialist, secular, democratic republic. It cannot be disputed that where corruption begins, all rights end. Corruption devalues human rights, chokes development, undermines justice, liberty, equality, fraternity, which are the core values in our preambular vision. Next slides are important. Therefore, the duty of the court is that any anti-corruption law has to be interpreted and worked out in such a fashion as to strengthen the fight against corruption. That is to say, in a situation where two constructions are eminently reasonable, the court has to accept the one that seeks to eradicate corruption to the one which seeks to perpetuate. This is the manner, my lord, of construction of a corruption statute.
Can I just take permission, come back in a moment? I'll just come back.
Now, my lord,
They will now hold for 7 to May.
I know this one.
6 years, 6 years. That's
So, my lord, the next judgment here was the 6A1. That's very important. The 6A quashing judgment, if I may use that phrase, is 2014, 8 SCC, 682. Also, my lord Subramaniam Swami. That's in the new compilation. 682. Your Lordship may note 4 paragraphs. 64, 68, 81 and 86. Lord, in the new compilation, it starts from page 1 and the relevant part, paragraph 64, my lord, at page 38 of the paper book. It's para 64 starts at page 38 bottom. The relevant part, my lord, which I wish to read, is on the next page 39, about 8 lines from top, sentence starting, my lord, if there is an accusation of bribery. If there is an accusation of bribery, graft, illegal gratification, or criminal misconduct against public servant, then we fail to understand how the status of offender is of any relevance. Where there are allegations against a public servant which amount to an offense, no factor pertaining is very important. No factor pertaining to expertise or decision making is involved. Yet 6A makes a distinction. It is this vice which renders 6A violative of 14. Moreover, the result of the legislation is that the very group of persons, namely high ranking bureaucrats, whose misdeeds and illegalities may have to be inquired into, would decide whether the CBI should even start an inquiry against them or not. There will be no confidentiality and insulation of the agency of political control and influence, and because the approval is taken by government, which will include leaks and disclosures. So they say that, Lord, you can't have a shield for the higher officers. Now can't turn to the next page, 68. 68. On the classification, again, my lord, in the middle of the paragraph, sentence starting, protection in 6A has the propensity of shielding the corrupt. The object of 6A, that senior public servants at the level of JS and above who take policy decisions must not be put to harassment, sidetracks the fundamental object of the PC Act to deal with corruption and act against senior public servants. CBI is not able to proceed even to collect material to another prima facie substance into the merits of allegation. Thus, the object of Section 6 is discriminating. This being the position, discrimination cannot be justified, etc. Now, Your Lordship may see 81 and 86. 81, my lord, is starting at page 43, at 44, after the quotation, my lord, above para 82, dealing with section 19 of the PC Act, which bars the court from taking cognizance of cases of corruption under so and so, unless the central or state government has a power to sanction. Observe that this provision virtually imposes fetters on private citizens and also on prosecutors from approaching the court against corrupt public servants. Public servants are treated as special class of persons, enjoying the protection so that they can perform duties by fear of favor without threat of malicious prosecution. But the protection against malicious prosecution, which is extended in public service, cannot become a shield to protect officials. Whether it's 197, whether it is 17A, whatever it is not, my lord, a shield. Now, my lord, 86 at the foot of page 45. The criminal justice system mandates that any investigation into a crime should be fair in accordance with law, should not be tainted. Equally important that interested or influential persons are not able to misdirect or hijack the investigation so as to throttle a fair investigation. Now, my lord, I wish to, my lord, read a few paragraphs of the counter affidavit which I filed in the High Court to show, my lord, what we have found in these few days. And if, my lord, this attempt is successful, it will nip the investigation in its bud. And that, my lord, should be abhorred. Lord, my counter affidavit in the High Court is volume 4, my lord. Yes, please. Kindly turn, my lord, to the counter affidavit in the High Court. It starts, my lord, in volume 4. Kindly turn, my lord. So to show, my lord, that this is not a vendetta of the state, see how many central agencies are examining the issue. I am not the only one. My lord turns to page 4 of the counter in, my lord, volume 4, page 4. Page 4.
What
Page
is
4.
this? This is your counter
My
affidavit.
counter in the High Court to the quashing petition. Lord, page 4 bottom. Now first see, my lord, DGST. Now DGST, my lord, is the center. They are examining, my lord, the scam, the same scam, running into more than so many crores, etc., etc. That 14th May letter, my lord, there is a mention from within the DGST. Now turn to the next page. SEBI. The present complaint is based on the fact that the amount of 370 crores swindled and transferred to shell companies, from where accused person, including the petitioner, withdrew the amount in cash. It is important to know that in organization no less important than SEBI is conducting an investigation. Income tax authorities. The authorities have independently examined the specific role of the petitioner, albeit in relation to other transactions, and have come to the conclusion that petitioner indulged in large-scale fraudulent cash transfers. It has been found by the anti authorities that the issue of the petitioner, huge amounts were released by the government in favor of certain private entities, including so and so, so and so, so and so, so and so, so and so. Now, my lord, your lordship turns to now what happened, my lord, in the instant case. I may just tell your lordship in one line instead of reading everything. The allegation is, my lord, that AP Skill Development Corporation was formed. The object was to provide, my lord, skill development to the youth of the nation. For that, my lord, they entered into an agreement with two companies. One is Siemens and one is another company. It is called Design Tech. There was no tender. So two companies are called. We have to set up 6-7 centers across the state. So the idea originally was, my lord, they will put in 90% and the state will put in 10%. But when the agreement was executed, this 90-10 was, my lord, kind of missing. But whatever it is, the fact of the matter, what we found was that before anything was set up, 350 or 70 odd crores was parted by the development corporation in favor of these two companies without looking at what is on the ground and overruling the objections of the department. Don't do it till you see what is going on. So 370 crores was given away, and that 370 crores was transferred by these companies to certain shell companies, and those shell companies withdrew monies in cash, hundreds of crores out of the 370. It withdrew it in cash, and most of it went back to the petitioner. That, my lord, is the nature of the scam which we allege.
Decision was taken at what level?
By the level of the chief minister.
The cabinet?
Yes, by the chief minister. I can show to you, my lord, one by one. That's why this detailed counter was filed. It is not, my lord, just a flippant thing, exercising open, giving an allegation. This is the nature of the scam. We may be right, we may be wrong. But this has to be investigated. It is, my lord, on record that this is how the corporation was formed. This is how the agreements were made. This is how there was no tender. This is how people protested in the department.
How do you trace back the money to the petitioner?
My lord, the allegation is this money of 370 was given to two companies. Companies are known, my lord. Those companies transferred these monies to shell companies. Those shell companies withdrew monies in cash. And it is our case that since he had formed this corporation, without tender, he had agreed that, my lord, these two parties could have, my lord, this agreement. It is our allegation that nothing on the ground happened and this went back, or at least some portion of it went back. Income tax is looking at it. SEBI is looking. How many authorities are looking at it? 100 crores cash was withdrawn is the finding of the income tax. So, my lord, one transaction can trigger many acts. It triggered SEBI, it triggered IT, it triggered GST. Where is the question, my lord, of vendetta? He keeps talking about vendetta. This is what it is triggering, and this is what my affidavit is. How can such an affidavit be ignored and say, oh, 17A, quash everything? We can't put blinkers, my lord. These are public funds. We are bound to investigate something which started in his own regime in the year 2018. And he says, forget all the other offences. Under, we have PC Act plus 10 others. How can you, remove everything? Forget 17A. So 17A plus many others are, all here. Any further
Yes.
Yeah, now, very quickly, 2-3 more pages of this, and I don't
That's
want
what we were just discussing, because we would also like to argue that 67. So.
Yes.
to argue.
Yes.
67.
Item 67. So you
No,
can
I-
continue on Monday, there is no problem, but leave some time for him to argue
Mr.
67.
Salve is also on the screen. He may be unmuted. Mr. Salve.
I will still take,
After he
I
finishes.
have to take another half an hour.
No, this has to carry over now. We cannot conclude hearing this matter
Yes.
today.
I need another half an hour. I have to cite, my lord, show this, then cite Niharika, and then, my lord, I want to give a comment on Justice Joseph's verdict in Rafael, which they were citing.
No, no,
Yes.
it's okay.
Yes.
Next week, possibly it's a miscellaneous week.
Yes.
Yes.
Going by the trend, from 2 p.m. we can
Yes.
take up this matter.
Your lordship, take it up on Tuesday.
No, no.
Because Monday I have some another part which I have to finish, my lord.
This is also part of.
I know, but my lord, that's an earlier one. Instead of Monday, keep it Tuesday.
Or if
If
this,
your lordships can. If your lordships can't, my lord, I will do whatever.
Subject to his.
not I'm sorry, not on this. Our case is not because it'll change the if we are lucky, if we are successful. If we are successful, it's a different matter. But if we are successful, then it changes the contours of the matter. I think Mr. Salve wants to say something. He may be kindly unmute.
Unmute, Mr. Salvi.
Can you unmute Mr. Salve? No, अभी लॉक है।
Voice over.
नहीं अभी आपके यहाँ से लॉक दिखा रहा है।
Sorry.
సాల్వే
नहीं
గారు
अभी भी लॉक दिखा रहा है।
వెబ్సైట్లో నుంచి విచారణ నిమిత్తం వచ్చారండి. సాల్వే గారు వాదన
फिर हो गया जी।
వినిపించడానికి సిద్ధమయ్యారు.
आपको अनलॉक करना। It's locked it out.
May,
No, it's.
Lord, I was saying so far of all that I've heard from Mr. Rohgi, I need 15 minutes, 20 minutes max for a reply.
Okay. So,
So if your lordship can accommodate me on Monday,
yes,
Lord, I was requesting Tuesday. I have some difficulty on Monday.
subject to agreement.
Monday, I'm not subject to Mr. Salve. Sir, Mr. Salve, Monday 3 o'clock or whatever, because Mr. Rohgi takes half an hour, Mr. Salve will take.
I have difficulty on Monday, but I'm only requesting for Tuesday. Can't be only on their
No,
accommodation.
I'm leaving it as between the two.
I have been here, your lordship said be
The
here.
two
I'm here.
Mr. Salve,
He has put in another case, Lord, which is taking away hours.
Mr. Rohatgi is
I have difficulty on
asking
Monday.
for Tuesday. Is that okay with you?
but, Not only normal as a council, it doesn't matter about Monday or Tuesday. Only somebody is in incarceration. That's all.
Yes, so just one day.
Incarceration has nothing to do with the 482.
I see.
Incarceration is to do with bails, all his bails.
I
are
think
revoked.
my learned friend should not try and
I'm not trying anything. A 482.
forecast what the end result of the hearing.
We are hearing on a day-to-day
Yes, yes,
basis.
no problem. Sir.
Exactly.
All his bails are rejected. He has to get bail because in a bail petition. Not in a 482. Anyway,
Only on scheduling, I said somebody
Yes,
is
yes,
in
no problem.
incarceration. That's why there is a pressure.
keep it Tuesday
We'll take it up on Tuesday,
at 2
What
o'clock.
time, sir?
2 o'clock.
2
o'clock Tuesday. Very well. Very well. 2 o'clock on Tuesday.
Yes.
But
Tuesday
we
కి
will
వాయిదా
finish on
వేశారండి.
Tuesday, I hope.
అలర్ట్
Yes, yes,
అండి
sir.
చంద్రబాబు నాయుడు గారి క్వాష్ పిటిషన్ని మంగళవారానికి వచ్చే మంగళవారానికి వాయిదా వేశారు.
No, no.
అయితే
No, no, the
మంగళవారం
other
మనకి
matter, I must tell your lordship, just take a few dates. It's actually
Just one
దసరా
minute.
సెలవులు కూడా ఉన్నట్టున్నాయి.
Are in part and adjourned till Tuesday. On that date, this matter shall be listed at,
ఏదో చెప్పాలనుకుంటున్నారు చంద్రబాబు నాయుడు గారి తరపున లాయర్లు. చూద్దాం. ఆల్రెడీ చంద్రబాబు నాయుడు గారు రాజమండ్రి సెంట్రల్ జైల్లో అస్వస్థతకి గురయ్యారనే ప్రచారం కూడా జరుగుతుంది. అది దాని మీద జైలర్ గారి లెటర్ కూడా ఒకటి వైరల్ అవుతుంది.
I'm not if I'll just submit. But kindly just consider the first
అయితే ఇవాళ
FIR
ఫైబర్ నెట్
against
కేసులో చంద్రబాబు నాయుడు
all
గారు
these
ముందస్తు
cases
బెయిల్ పిటిషన్
happened
మీద హైకోర్టు
in
రిజెక్ట్ చేస్తే దాన్ని
2021,
సుప్రీంకోర్టులో
2021.
ఛాలెంజ్ చేశారు.
And one of these instances was the FIR your lordships, this court has been hearing, which is FIR 29 of 21, which relates to what is called skill development. That's the one that's going on in 17A. Now that, you know the facts from 8 September, after detention,
ఇదే కేసులో
since
సిద్ధార్థ్ రుద్ర గారు
2021,
వాదనలు
registered
వినిపిస్తా
no
ఉన్నారు
17A, 8 September they arrest me for the first time. Then I'm
క్యాష్ పిటిషన్ మీద.
run through the rigmarole of police custody, and now I spent about a month in custody. There is another case called FIR 16 of 22, where they have also sought to get PT warrants issued against me. Similar situation where the Honorable High Court has passed an order which I'll just pass over. This order has been passed over. Does your lordship have it? Or I'll give another. The papers it may have got mixed up. I'll give you a copy.
అదండి సిద్ధార్థ్ రుద్ర గారు ఏమంటారంటే పీటీ వారెంట్ల కోసం కూడా అప్లై చేశారు సిఐడి వాళ్ళు. ఇది కూడా
This is in
విజయవాడ
respect of
ఏసీపీ కోర్టులో
FIR
పాస్ చేశారని
24
చెప్పేసి దాని మీద
Now
కూడా
we are
వాదనలు
reading
వినిపిస్తున్నారు.
24.
కాబట్టి
This is the order in
ఈ
16
సెక్షన్
of
17 మీద వీలైనంత
In
త్వరగా
16
మీరు
of 22,
తీర్పు ఇవ్వాలని
please come
చెప్పేసి
overly.
రిక్వెస్ట్ చేస్తా ఉన్నారు.
Last but one para, considering the submissions, this court adjourns the matter to 16th October. It is directed that trial court shall not proceed further in the petition filed under 267 by criminal MP till the next date of hearing.
చూసినట్లయితే విజయవాడ
In
ఏసీపీ
that case,
కోర్టులో
what
పెద్ద
they
గొడవ
did was,
జరిగిందని
and I must
చెప్పుకోవచ్చు.
make it clear,
ఎప్పుడైతే చంద్రబాబు నాయుడు గారిని
once they
అరెస్ట్
arrested
చేశారో
me
ఆ
in one
కేసులో
case,
ఉన్నటువంటి
they
సిఐడి
have started
అధికారుల కాల్
booking me in every
రికార్డింగ్
case
మొత్తం కూడా
possible.
సేవ్ చేయాలని చెప్పేసి
And
విజయవాడ
the
ఏసీపీ
current
కోర్టులో
FIR, which is
చంద్రబాబు
called
నాయుడు గారి
a
తరపున
fiber
లాయర్లు
grade,
అప్లై చేశారు.
FIR
అయితే
24 of 21 is
ఇంకో
one
విషయం
such
ఏంటంటే
case
ఆ రోజున
where from
చంద్రబాబు నాయుడు గారు
9th
రిమాండ్ విధించిన
December
రోజున
21 when the FIR get registered, 9th
ఆ విషయం వెళ్ళేసి
December
అధికారికంగా
21
మాకు
when the FIR
పత్రాలు
gets
ఇవ్వాలని
registered,
చెప్పేసి
no
జడ్జి గారిని
action is
మన
taken
చంద్రబాబు నాయుడు గారి
whatsoever
తరపున లాయర్లు అడిగారంట.
in this matter.
అయితే ఆ విషయం
Some
జడ్జి గారు
statements
ఏం
are
చేశారంటే
according to
విజయవాడ
2022,
సిపి
and for the first time in
క్రాంతి రాణా టాటా గారికి
2023,
చెప్పారంట.
they come up with some kind
క్రాంతి
of
రాణా
notice
టాటా గారు
statement,
వచ్చేసి
and then they
చంద్రబాబు
say
నాయుడు
we
గారి
have
తరపున
identified
లాయర్ల
the
మీద
accused. Now there is a
వార్నింగ్లు
practice
ఇచ్చి
in,
ఏదో గొడవ
as I said, in
చేశారంట.
the southern states,
అయితే నేను
where
దీని
on-
మీద పెద్ద
after
వాదనలు
being
జరిగింది
arrested in
విజయవాడ
the first
ఏసీపీ
FIR
కోర్టులో.
on 9th,
మేము
19 September, they
న్యాయమూర్తి
admitted
గారిని
the
అడిగితే ఆ విషయం క్రాంతి రాణా గారికి ఎలా తెలిసింది, విజయవాడ సిపి
As
గారికి ఎలా
825,
తెలిసింది. కాబట్టి
they
జడ్జి
moved
గారి
an
మీద కూడా మాకు
application
అనేక అనుమానాలు ఉన్నాయని
under section
చెప్పేసి
267
చంద్రబాబు నాయుడు తరపున
CRPC,
లాయర్లు ఆరోపణలు వ్యక్తం
which they
చేశారు. దాని మీద నిన్న
seek
కోర్టులో
orders
పెద్ద
on,
గొడవలో
where an order has now
జరగడంతో
been passed that I
విజయవాడ
should be
ఏసీపీ
produced
కోర్టు
for the court
న్యాయమూర్తి
on Monday,
హిమబిందు
that is
గారు
16th of
బెంచ్ దిగిపోయి
uh,
లోపలికి
October
పారిపోయారని చెప్పేసి
2023.
మనకి ఇవాళ ఒక
My
న్యూస్
concern and my
ఆర్టికల్
fear is
వచ్చింది.
this. They will arrest me the moment I appear. I'm produced before the court and my liberty will be lost. Now, the difficulty that we have in all these cases is, and if this court just looks for a moment at this FIR, the FIR relates to certain allegations that a tender was floated and it was given to a certain party which was taken out of a blacklist and that was benefited. All very well. But the interesting part is that in the FIR, if this court just has page 33 for a moment, I am mentioned as an accused, which you will find in the body of the complaint at page number 45. The complaint begins at page 43, but I'm not made an accused. Page 43 is where the complaint comes, the letter comes. And at page number 45 bottom, in AP, please see the bottom. In AP fiber grid project phase 1, there was a orchestrated conspiracy involving one Chief Chandrababu Naidu, then Chief Minister, etc. This is the basic preliminary inquiry. All of this goes on. They make whatever they have to say. Unfortunately, and they also come to page 65. Page 65.
So that is
Second-
what Mr. Rudri says, that this is not out of vendetta.
I'll
Political vendetta.
tell your leadership.
After some material having been found,
Leadership,
you have been.
leadership, I'll tell your leadership in this case, what has happened is, the interesting part here is, they claim that they've done an inquiry. Again, there's a 17A bar here. No 17A here again. We raised this point, addressed it to the High Court. High Court doesn't consider it. It's argued, noted. Our argument, their argument, High Court just bypasses that completely. And second and thirdly, in this case, there are 3 people on anticipatory bail. I'm going to pass over those orders, and 3 on regular bail. Others they've not arrested. Please see these orders. And in those orders, what has been stated? That all the material is with them, no question of arrest. Now, please just look at the index for a moment. The first order relates to the member of the tender committee. That's A1, anticipatory bail, order of 29 September 21, not challenged till this court. I'll come to the details later. The second order is a post-arrest order relating to A2. A2 was the chairman of this organization, AP State Fibernet Limited, who's a member of the government, IRTS, Indian Rail Transport Service, Rail Traffic Service. Then you have the third order of A11. A11 is MD of the beneficiary company, Terrasoft, anticipatory bail granted. Then you have the fourth order, A22, director of a company which is the project management consultant. Now, if all these people are on anticipatory bail or on regular bail, and there are 2 others who are on regular bail, I'm told from the trial court, I ask myself, where is the question of taking me into custody in this matter? And that's the point. Please consider these transactions relate to 2017. I'm in the state, elections around the corner.
Mr. Luthra,
Yes, sir.
the 17A point is overlapping.
Completely.
So what we'll do, we'll issue a very short notice. We'll request Mr. Wadgi to accept notice. We'll take it up on Tuesday.
Yes, sir. But meanwhile, the issue is this. Monday, production warrants have been issued for. Those may be kept in abeyance. Not so if I'm not
Why should
into
I
custody.
have to argue? There's a question
It's
about
only till Tuesday. Not put it simply. No, please see. If
Not
the
if
High Court
anything
has
changed in
order-
any case, how can he get out?
Just a minute, Mr. Rodki. In
How
the
can he be out?
I must say this, Lord, what because they're making this, they're taking me in this circus, Lord. In another case where they tried to rope me in, please see the High Court order. High Court has kept the warrant in abeyance, even in that. I'm just asking, Lord, keeping the warrant in abeyance till
No,
Tuesday.
I am opposing it.
Stand on different footing
Absolutely.
as such.
I'm sorry,
From the allegations it appears.
Leadership, I'll make good.
You would stand on different footing. Whether 17A is applicable or not,
Yes.
we are still hearing the
Yes, so,
arguments.
no, I'm on something else.
But I'll show you the allegation.
You are in custody. So
Leadership,
whether you get anticipation in this case or not,
That's right.
I'll give the answer.
much difference.
May I make-
Except that,
May I,
except that if you win, you will also get the regular bail.
may I make this? No, this will
You are
become,
arrested.
I'll tell your leadership, it'll become
Your
infructuous.
regular bail is
Just a
included in
minute,
those
sir,
cases.
please.
Yes.
Mr. Rodki, please. The difficulty is this. Production warrant order has been issued to produce me on Monday. Monday they'll arrest me, Tuesday they'll be infructuous. All I'm saying is, till Tuesday, the production warrant ought not to be
I'm sorry,
acted
bro.
upon.
Can't
Because
be like-
otherwise, Tuesday, if please consider this. If the production warrant, if Monday they arrest me, before today and Monday they can arrest me anytime, this petition will become.
Can you do this? Till Monday, can you, we are not passing any
We are not
order.
passing any order, but you just.
Because the matter is before the court, not in my
The
hand.
order's been passed. I'll show you.
The matter is before the,
So not,
because I can't, see what has happened in
This is
this.
anticipatory bail.
Yes,
The normal order is that in case of arrest,
that is if your lordships are inclined. But today,
Inclined.
matter has not been.
so if we are,
It's just-
you
I understand.
hold the arrest, we are not passing any order,
Please see the,
not to arrest him on
at
Monday.
least 2 days, because we are in the midst of hearing.
I have no problem, but I will just tell
Tuesday.
you.
Because he is in any way in custody.
I will just tell you lordship what it
please
is.
see the order.
But he is in custody in the skill case. He is in custody. He is not in custody in
Become
this,
infructuous.
sorry.
This will become infructuous.
Yes.
So lordship can reverse it. Because in any case, my lord, it is before the
They're
court that we have moved an application for production.
You just stay on your hands on.
The judge will decide, my lord, I am not to decide.
No, judge will decide. if
You can tell the judge that we are not arresting him.
My learned friend is not right. Please see the judges.
Anyway,
On their request is a production order.
All right, but I will instruct that there should not be an arrest on Monday. Simple. Whatever the court will decide. Whenever, leave the lordships here. But there's Tuesday, Wednesday.
issue notice? Who accepts the notice?
Yes.
No, may I just say this? No, there's something which Lordship will have to do. Please just consider page 136 for a moment, because please see, my learned friend will have to be little circumspect. Please see page 136. The prayer that they made was to send him to JC. Now, if that may be clarified, it should not be that they say we are not arresting and meanwhile the court sends to JC. It should not become infructuous in that context. Please see the order I passed.
When I am saying that I am not going to arrest, what more is required?
My lord, may I just,
In the event you are out,
my lord, may I just
One
submit
court.
this?
Position.
No, I'm not, I mean, let me clarify. Now, I think I'm not being clear. In FI 29, I'm in JC. Now there is allow me 2 minutes. Not I'll just-
but just anticipatory bail application would not become infructuous unless there is an arrest.
Correct.
My lord,
If he doesn't arrest,
my lord,
That's what I'm saying.
if I may just point this out, and I'll leave your lordship with this thought. I completely bow before that. My concern is only this: the prayer in the 267 production
Lord, may
Just
I
a
allay
minute.
his apprehension?
was.
I will ask the court to adjourn the matter to Wednesday.
Fair.
Simple.
fine.
So that I am not arresting, court will not do, but that's the end of the
I
matter.
think that's fair.
This notice,
I am not fighting on days. mate.
Mr. Nazki,
That's right. Mahfouz Nasr.
So I'll file a reply, my lord, by Monday.
you are the
Mr.
standing,
Dusky,
That's right.
Nazki, Mr.
Dusky.
Standing Counsel for State of
State of
Andhra
Andhra.
Pradesh accept service on behalf of the respondent state. List this matter on Tuesday.
That's-
Lord,
But your opportunity to file a reply by Monday.
In the event the
I will file
state wants to file a counter affidavit,
by
the
Monday.
same may be filed by
By
Monday with a copy
Yes,
to the.
We are not
petition.
passing any order.
that's all right.
But your
But if your
lordship,
lordship
we
don't,
have We have Mr.
Statement of. at the
Statement, fair enough. Mr. Redki's statement is good as gold. So no arrest and.
I have said that.
No, I'm just, Mr. Redki.
I have said
I
it
just
now,
want
how many times
clarity
you want
to
me to
instruct
say?
my juniors. So no arrest till Wednesday and they'll ask the court to defer it on Monday.
Yes, what else?
That's fair.
Lordship,
Deeply obliged.
very grateful.
Grateful. I'm most obliged.
అదండి పరిస్థితి. ఫైబర్ నెట్ కేసులో ముందస్తు బెయిల్ పిటిషను ఏపీ హైకోర్టు రిజెక్ట్ చేయగా దాని మీద సుప్రీంకోర్టులో ఛాలెంజ్ చేశారు. అయితే దాని మీద సోమవారం వరకు ఫైబర్ నెట్ కేసులో చంద్రబాబు నాయుడు గారిని అరెస్ట్ చేయొద్దని చెప్పేసి ఉత్తర్వులు జారీ చేసింది సుప్రీంకోర్టు. అలాగే ఆ పిటిషన్ మీద విచారణని వచ్చే మంగళవారానికి వాయిదా వేసింది. అలాగే మన స్కిల్ కేసులో కూడా చంద్రబాబు నాయుడు గారు ఇచ్చిన క్వాష్ పిటిషన్ని వచ్చే సోమవారానికి వాయిదా వేసింది సుప్రీంకోర్టు. ప్రస్తుతానికి ఇవి ఉన్నాయి. సుప్రీంకోర్టులో ఈరోజు జరిగిన చంద్రబాబు నాయుడు గారి కేసులో జరిగిన సుప్రీంకోర్టులో ఈ 2 పిటిషన్లకు సంబంధించిన తీర్పులు అయితే ఇలా ఉన్నాయి. మరోవైపు విజయవాడ ఏసీబీ కోర్టులో ఏం జరిగిందో ఇలా ఇందాక ఆల్రెడీ చెప్పున్నాను నేను. అలాగే ఆంధ్రప్రదేశ్ హైకోర్టులో అంగళ్ళు పొంగనూరుకు సంబంధించిన అల్లర్ల కేసులో చంద్రబాబు నాయుడు గారికి ముందస్తు బెయిల్ పిటిషన్ ఇచ్చింది. ఏపీ హైకోర్టు ₹1,00,000 పూచీకత్తుతో. ఇవాటితో శుక్రవారం కాబట్టి రేపు శనివారం సెకండ్ సాటర్డే, ఎల్లుండి ఆదివారం సెలవు కాబట్టి మళ్ళీ సోమవారం కలుద్దాం. సోమవారం మళ్ళీ లైవ్ పెడతాను. అంతవరకు మన ఛానల్ని సబ్స్క్రైబ్ చేసి చూస్తూ ఉండండి.
నమస్తే, మీరు చూస్తుంది తెలుగు రైతుబడి. నా పేరు రాజేందర్ రెడ్డి. ఈరోజు ఈ వీడియోలో మనం కుందేళ్ల పెంపకం గురించి పూర్తి సమాచారం తెలుసుకునే ప్రయత్నం చేద్దాం. హైదరాబాద్ నగర శివారులో ఉన్న కోహెడా గ్రామంలో మనం ఉన్నాం. ఇటువైపు విజయవాడ హైవే, ఇటువైపు నాగార్జున సాగర్ హైవే, రెండింటికి మధ్యలో ఈ కోహెడా గ్రామం ఔటర్ రింగ్ రోడ్డుకు సమీపంగా ఉంటుంది. ఇక్కడ గత 3-3.5 సంవత్సరాలుగా కుందేళ్లు పెంచుతున్న రైతు సురేందర్ రెడ్డి గారు, కొత్త సురేందర్ రెడ్డి గారు మనతో పాటు ఉన్నారు. వారితో మాట్లాడి మొత్తం ఎన్ని కుందేళ్లు వీళ్ళు పెంచుతున్నారు, వాటికి ఏ దానా వేస్తున్నారు, గడ్డి ఏం వేస్తున్నారు, ఎన్ని రోజుల పాటు పెంచిన తర్వాత కుందేళ్లను ఎవరికి అమ్ముతున్నారు అనే పూర్తిస్థాయి సమాచారం వారిని అడిగి తెలుసుకునే ప్రయత్నం చేద్దాం. నమస్తే అండి. ఎన్నాళ్ళుగా కుందేళ్లను పెంచుతున్నారు? మొత్తం
నేను 3 సంవత్సరాల పైన అయిపోయింది అన్న.
3 సంవత్సరాల పైన అయిపోయింది.
4వ సంవత్సరం అంటే ఇంకొక 2-3 నెలలు అయితే 4 సంవత్సరాలు.
4 సంవత్సరాలు అవుతుంది. ఇంకొక 2-3 నెలలు అంటే 3 సంవత్సరాల మీద ఒక 7-8 నెలలు అవుతుంది.
7 నెలలు.
ఎంత షెడ్ వేసుకున్నారు? మొత్తం కుందేళ్ల కోసమే వేసుకున్నారా? అంతకుముందు వేరే ఏమైనా ఉండేనా ఇందులో?
లేదన్న, ఫస్ట్ కుందేళ్ల గురించి.
కుందేళ్ల గురించే వేసుకున్నారు. ఎంత ఉంటుంది షెడ్?
ఇది 30 సైజు ఉంటుంది. 120 120 పొడవు,
120 అడుగుల పొడవు, 30 అడుగుల వెడల్పు తోటి ఒక షెడ్ వేసుకున్నారు. మధ్యలో ఒక 15 అడుగుల హైట్ ఉంటుందా?
15 అడుగులు.
15 అడుగులు అటు ఇటు దిగేసరికి ఒక 10-12 అడుగులు.
ఇది లాస్ట్ పోల్స్ వచ్చేసరికి 8 ఫీట్లు.
ఎంత ఖర్చు వచ్చింది అప్పుడు మీకు 4 సంవత్సరాల క్రితం వేసుకున్నప్పుడు షెడ్?
నాకు 4 లక్షలు చిల్లర, అంతే. 3.5 నుంచి 4 లక్షల వరకు వచ్చింది.
3.5 నుంచి 4 లక్షలు ఆ రోజు. ఎంత భూమిలో వేసుకున్నారు? మొత్తం ఎంత ఉన్నది మీకు?
సొంత పొలం.
మీ సొంత పొలం ఎంత ఉన్నది ఇక్కడ మొత్తం మీకు?
ఇది నాకు 3 ఎకరాలు ఉంటుంది.
మొత్తం 3 ఎకరాల భూమి ఉన్నది. ఇందులో 400 గజాలలో షెడ్ వేసుకున్నాం. సుమారు 4 లక్షల రూపాయలు 4 సంవత్సరాల క్రితం వేసుకున్నాడు ఖర్చు. ఓకే. 3-3.5 సంవత్సరాల క్రితం ఇది మొదలు పెట్టినారు కదా. ఎన్ని పిల్లలతోటి మొదలు పెట్టినారు?
నేను తల్లులు ఒక 3 యూనిట్లు తెచ్చిన.
3 యూనిట్లు అంటే
3 యూనిట్లు అంటే యూనిట్కి 2 మగయి 8 ఆడి ఉంటాయి. అయితే అట్లాంటివి నేను 35 తెచ్చిన. 35లలో నాకు 6 మగయి వచ్చినాయి, మిగతా ఆడి వచ్చినాయి.
24 ఏమో ఫీమేల్,
అంతే.
6 ఏమో మేల్, మొత్తం 30 ఇచ్చిన.
35
అంటే దాన్ని 3 యూనిట్లు అంటారు.
3 యూనిట్లు.
ఏం ధర పడ్డది అప్పుడు మీకు?
నాకు 13,000 యూనిట్ పడ్డది.
ఒక్క యూనిట్ కు 13,000. అంటే 10 ఇటుకి ఒక్కొక్క దానికి 1,300 రూపాయలు పడింది. అంతే కదా, యావరేజ్ 13,000 అంటే 3 యూనిట్లకు కలిపి 39,000 రూపాయలు మీకు ఖర్చు.
39,000.
అంతకంటే ముందు ఇప్పుడు ఈ కేజ్ ఈ బాక్సులు ఉన్నాయి కదా, ఇవన్నీ ఎట్లా సెట్ చేసుకున్నారు? దీనికి ఎంత ఖర్చు అయింది, ఎన్ని పెట్టుకున్నారు ఫస్ట్?
అయితే ఈ జాలీలు కొత్తగా చేసుకుంటే నాకు రేట్ ఎక్కువ అవుతుంది. అయితే నాకు ఇంతకుముందు మా ఫామ్ తిరిగి వచ్చిన కదా నేను, ఆయన ఏమైంది, ఆయనకు ఒక జాబ్ మానేసిండు కరోనాలో. ఆ ముందులా మానేసిండు కాబట్టి కరోనా ఆయనకు సెట్ అవుతలేదు బిజినెస్. అన్న నా దగ్గర జాలీలు ఉన్నాయి తీసుకొని పో అంటే ఆయనకు సెకండ్ హ్యాండ్లో నేను 30,000 రూపాయలు పెట్టి జాలీలు తెచ్చు.
ఈ 4
అంటే ఆయనకు ఒక 30,000 ఇచ్చి ఆ 2 స్టెప్పులు తెచ్చుకున్నా, ఇంకొక 30,000 ఇచ్చి ఈ 2 స్టెప్పులు తెచ్చుకున్నా.
వేరే
రెండు
60,000 అయినాయి.
60,000 జాలీలు.
ఇప్పుడు 4 లక్షల షెడ్కి అయినాయి, ఒక 40,000 పిల్లలకు కుందేలు పిల్లలకు అయినాయి 3 యూనిట్లకు, తర్వాత ఈ ఒక 60,000 అయినాయి. ఇంతేనా, ఇంకేమైనా?
ఈ పెట్టుబడి
మొత్తం 5 లక్షలు అయింది.
5 లక్షలు
సుమారుగా. 5 లక్షల పెట్టుబడితో మొదలు పెట్టినారు. 10 పిల్లల 10 కుందేళ్ల చొప్పున మొత్తం 3 యూనిట్లు తెచ్చుకున్నారు కదా. ఎన్ని రోజులు పెంచినాక ఇంకా మీకు మెల్లమెల్లగా మళ్ళీ ఏమైనా తెచ్చిరా? అవి వాటి నుంచి
అవే నా 3 యూనిట్ల నుంచే ఇదంతా డెవలప్.
ఎన్ని ఉన్నాయి ఇప్పుడు మొత్తం?
నా దగ్గర ఇప్పుడు 180 బ్రీడర్స్ ఉంటాయి.
180 అంటే మీరు 30 బ్రీడర్లు తెచ్చుకున్నారు, 180 బ్రీడర్లు అయినాయి.
180 బ్రీడర్స్ అయినాయి. నేను చాలా బ్రీడర్స్ కూడా అమ్మిన. బేబీస్ అయితే చాలా
ఉంటారు సుమారుగా.
బేబీస్ అంటే ఇక నాకు లెక్కలు ఏం రాసుకుని నా ఓన్ ఊరికి లెక్కలు చెప్పేది ఉండదు కాబట్టి ఇక నాకు సేల్ బాగానే ఉంది. అంటే నెలకు వచ్చేసరికి అట్లా రేర్గా ఇన్కమ్ అట్లా వచ్చేటట్టు చూసుకుంటాం.
మీరు ఎంతమంది పని చేస్తారు దీని మీద మొత్తం?
నేను నా భార్య ఇద్దరు.
మీ భార్య, మీరు?
మా అమ్మ కూడా సహాయం చేస్తుంది.
మీ అమ్మ కూడా సాయం చేస్తారు. ఎంత పని ఉంటుంది రోజు దీంట్లో?
నాకు పొద్దున్నే 5:30 ఖచ్చితంగా లేస్తా.
5:30. ఎంత దూరం మీ ఊరు పక్కకున్నట్టుంది కదా?
మా ఊరు 1.5 కిలోమీటర్ ఉంటుంది.
1.5
కిలోమీటర్ ఉంటుంది. 1.5 కిలోమీటర్ నుంచి ఇక్కడికి వస్తాను. ఫామ్
ఉదయాన్నే వస్తా.
5:30 ఖచ్చితంగా నేను ఫామ్.
దీనికోసం ఎంత గడ్డి వేసుకున్నారు చుట్టూ?
నేను 1.5 ఎకరం గడ్డి వేసిన.
1.5 ఎకరం భూమిలో గడ్డి వేసిన. ఏమేమి గడ్డి ఉన్నది మీ దగ్గర?
నా దగ్గర హెడ్జ్ లూసన్ ఉంటుంది, కోఫై ఉంటుంది, కోఎస్ఎఫ్ 31 ఉంటుంది.
కోఎస్ఎఫ్ 31 ఏది మన ఈ
సొప్పజాత్. ఇదేమో ఇది కోఫై అన్న, నిన్న వేసింది నేను. ఇది కోఫై, ఇది సొప్పజాత్ ఏమో కోఎస్ఎఫ్ 31. ఇది హెడ్జ్ లూసన్ ఏమో ఇక మీకు తెలిసింది. అది
హెడ్జ్ లూసన్ కూడా మనం మేకలకు వాటికి వేసుకునేది. అయితే చలికాలంలో ఈ 3 కాకుండా నేను ఇంకా పొలం ఎక్స్ట్రా ఒక 30 ఎకరా పెట్టుకుంటా. ఏది ఈ 3 కూడా చలికాలంలో ఎదుగుదల తక్కువ ఉంటుంది. ఈ 3
రకాల ఎదుగుదల తక్కువ ఉంటుంది.
లూసన్ గానీ కోఫై గానీ
ఈ 3 తక్కువ ఉంటాయి. ఈ అప్పుడు సరైన గడ్డి అందుబాటులో ఉండదు, కుందేళ్ళు మనకు అందుబాటులో ఉండదు కాబట్టి లూసన్ విపరీతంగా వస్తుంది.
ఇది లూసన్ కదా,
ఇది హెడ్జ్ లూసన్ అన్న.
అదే హెడ్జ్ లూసన్.
ఇది హెడ్జ్ లూసన్. ఇది లూసన్ అనేది వేరే ఆకులాగా వస్తుంది,
కొంచెం ఆకులాగా పూర్తిగా
కూర టైప్ వస్తుంది. అది వేసుకుంటా.
ఓకే. మళ్ళీ ఎండాకాలంలో వేరే వేసుకుంటా?
ఎండాకాలంలో ఇది విపరీతంగా వస్తాయి అన్న.
ఎండాకాలంలో ఇవి విపరీతంగా వస్తాయి, యాసంగిలో చలికాలంలో అది వేసుకుంటా. ఓకే. సో ఇట్లా మార్చుకుంటారు. రోజు ఎన్నిసార్లు వేస్తారు వీటికి మేత?
నేను పొద్దున వచ్చి 5:30కి వస్తాను. ఫస్ట్ ఒక హాఫ్ అన్ అవర్ చెకింగ్ ఉంటుంది,
మొత్తం అన్ని చూసుకుంటారు.
అన్ని అసలు ఏంది కుందేలు అసలు గడ్డి వేసింది తిన్నదా, దాని వేసింది తిన్నదా, లేకపోతే అసలు మోషన్ ఉందా, సరదా అయిందా, అసలు ఏందనేది మొత్తం పూర్తిగా అన్ని ప్రతి కుందేలు ప్రతి పిల్ల చెక్ చేసుకుంటానా. ప్రతిదీ దానికి 8 పిల్లలు ఉంటే 8 చెక్ చేయాల్సిందే, పెద్దది ఉంటే కుందేలు చేయాల్సిందే.
ఇప్పుడు ఇది ఉంది, దీన్ని చెక్ చేయాలంటే ఎట్లా? దీన్ని తీస్తారా బయటికి?
తీస్తానా. ఇప్పుడు మనకి ఇది పైకి వస్తుందన్న, ఇది డల్ గా ఒక మూలకు వండుకుంది అనుకో, ఇది అరే దీనికి ఏదో ప్రాబ్లం ఉంది.
ఒకసారి తీయండి, చూపిద్దాం దాన్ని. ఇది ఏం వెరైటీ? ఎన్ని రకాల బ్రీడ్స్ ఉన్నాయి మొత్తం?
నా దగ్గర 7 నుంచి 8 రకాలు ఉంటాయి. డచ్లు ఒక 5-6 రకాలు ఉంటాయి అన్న.
డచ్ అనే వెరైటీలు 5-6 రకాలు.
డచ్లు అనేది ఎట్లుంటది అంటే, ఇప్పుడు న్యూజిలాండ్ మేల్ ఉంది, బ్లాక్ జెయింట్ ఫిమేల్ ఉంది.
అసలు ఎన్ని పేర్లు చెప్పండి, మాకు తెలియదు కదా, చూసే వాళ్ళకు చాలా మంది తెలియదు. అసలు ఎన్ని రకాలు ఉంటాయి మొత్తం?
ఉంటాయి అన్న 35 నుంచి 36 రకాలు.
35 నుంచి 36 రకాలు.
కానీ మనకు అన్ని సెట్ కావు. మనకు ఒక డచ్లు, ఇప్పుడు ఈ డచ్ ఉంది అన్నది, ఇది రష్యన్ కు న్యూజిలాండ్ వైట్ కు వచ్చింది.
ఇప్పుడు ఇది ఏం వెరైటీ? మనం
ఇది న్యూజిలాండ్ వైట్ అన్న.
న్యూజిలాండ్ వైట్ అంటే ఎట్లా చెప్తారు న్యూజిలాండ్ వైట్ అని?
అన్న ఇది
వైట్ కలర్,
ఇది వైట్ కలర్, ఐస్ రెడ్ ఉంటాయి అన్న.
కళ్ళు రెడ్ కలర్ లో చూడొచ్చు,
రెడ్ ఐస్,
కళ్ళు రెడ్ కలర్.
ఇది న్యూజిలాండ్ వైట్. ఇది దీని స్పెషల్ ఏంటంటే ఇది ల్యాబ్ పర్పస్ కూడా పోతుంది, ప్రయోగాలకు చేసినకి ఇది పోతుంది. అందుకనే దాదాపు నేను ఎక్కువ న్యూజిలాండ్ వైట్ మెయింటైన్ చేసే ప్రయత్నం చేస్తుంటా. పెట్ షాప్ లో కలర్లు ఈ 2 కల్పిస్తే బాగా తీసుకుంటా. అంటే ఈ 2 మార్కెట్లు చూసుకుంటా.
న్యూజిలాండ్ వైట్ అనేది ఒకటి, ఇంకేమున్నాయి వెరైటీలు చెప్పండి ఫస్ట్.
న్యూజిలాండ్ వైట్ అన్న, వైట్ జైంట్,
వైట్ జైంట్,
రష్యన్ బ్రీడ్.
రష్యన్ బ్రీడ్ ఉన్నదా ఇక్కడ?
ఉన్నదన్న,
ఇది లోపల పెట్టి
ఉన్నది.
న్యూజిలాండ్ వైట్, రష్యన్ బ్రీడ్.
ఇగో ఇది డచ్ అన్న.
డచ్
ఇది ఏంది రెండిటికి కలిపితే వచ్చేది
క్రాస్ బ్రీడ్.
క్రాస్ బ్రీడ్ అన్న. క్రాస్ బ్రీడ్ ఇట్లా ఒక నుంచి 7-8 రకాలు
అంటే వైట్ కొంచెం మిక్స్డ్ కలర్
ఉంటాయి, ఒక 7-8 రకాలు ఉంటాయి. వేరేగా వస్తాయి, వేరేగా వస్తుంటాయి. ఇది బ్లాక్ జైంట్.
ఇది రష్యనా? ఇది
ఇది రష్యన్ అన్న. ఇది గోల్డ్ స్పాట్ అంటారు దీన్ని.
గోల్డ్ స్పాట్, గోల్డ్ కలర్ ఉంది.
గోల్డ్ కలర్ ఉంది.
తీయండి ఇది ఒకటి బయటికి. చెవులు పట్టుకొని తీయాలా?
ఈ చెవులు పట్టుకొనే తీయాలి. సరే, మీరు ఇంకా ఏమన్నా ఉంటే ఇట్లా పట్టుకొని చూడాల్సిందే. కానీ మీరు ఈడ పట్టుకున్న కాళ్ళతో అనడము, ఈడ అసలు నడుముకు పుట్టలో అసలు పట్టుకోవద్దు.
కరుస్తుందా?
కరవడం కాదన్న, దీనికి ఎఫెక్ట్ అవుతుంది. దీని లోపల అవయవాలు కొంచెం ఎఫెక్ట్ అవుతుంది. దీని బరువు మొత్తం పుట్టలేయాలంటే ఇబ్బంది.
కాబట్టి చెవులు పట్టుకొని
చెవులు పట్టుకొని. ఇది రెండో రకం పేరు చెవుల పిల్లి అంటారు దీన్ని.
అదే కుందేళ్లకున్న పేరు
రెండో చెవుల
అదే. సో ఇది గోల్డ్ స్పాట్ అనేది.
అవునన్న.
ఇట్లా డచ్ అని ఉన్నది, న్యూజిలాండ్ వైట్ అని ఉన్నది, తర్వాత గోల్డ్ స్పాట్ ఉన్నది, రష్యన్ ఉన్నది, ఇట్లా రకరకాల బ్రీడ్స్ మీ దగ్గర ఉన్నాయి. ఇప్పుడు ఈ ఒక పిల్ల అంటే ఒక తల్లి బ్రీడ్ జన్మనిస్తే ఎన్ని పిల్లల్ని పెడుతుంది జనరల్?
2 నుంచి 12 వరకు కూడా పెట్టవచ్చు.
2 పిల్లలు పెట్టవచ్చు, 12 పిల్లలు కూడా పెట్టవచ్చు. దీని లోపలికి
12 కూడా పెట్టవచ్చు అన్న.
12 పిల్లలు కూడా పెట్టవచ్చు. యావరేజ్ అయితే 5-6 అయితే కామన్ గా పెడుతుంటే
అన్న. 6-7 వస్తే నీకు మంచి తల్లి మంచిగా ఉంటుంది, పిల్లలు బాగుంటాయి అన్న. మిల్క్ సప్లై కూడా బాగుంటుంది.
ఇప్పుడు మగ కుందేళ్ళు ఉన్నాయని అన్నారు, ఆడ కుందేళ్ళు ఉన్నాయని అన్నారు. క్రాసింగ్ అయిన తర్వాత ఎన్ని రోజులకు పిల్లలు పెడుతుంటారు?
క్రాసింగ్ ఈ రోజు మనం క్రాసింగ్ చేసేటప్పుడు కూడా మనం ఎట్లా క్రాసింగ్ అయింది అనేది చూసుకొని సక్సెస్ అయిందా లేదా అనేది ఒక 15-16 డేస్ తర్వాత అది గ్రోత్ వస్తుంది, మంచి గ్రోత్ వస్తుంది. బాడీ పెరుగుతుంటది, వెయిట్ పెరుగుతుంటది. దాంట్లో చూసే విధానం అందరికి చూడరాదు,
మీరు రెగ్యులర్ గా చూస్తున్నారు కాబట్టి అర్థమైపోతుంది.
అది మనం పట్టుకొని కిందంగా పొట్టను పట్టుకుంటే దాంట్లో పిల్లలు ఉన్నట్టు కదులుతాయి. నొక్కి పడితే మళ్ళీ చనిపోయే ఛాన్స్ ఉంటాయి.
అబ్జర్వ్ చేయడానికి
అంతే. అది చేతులతోటే స్కానింగ్. ఇక వేరేది ఏది లేదు.
అంత టాలెంట్ ఉండాలి. అది ఎక్స్పీరియన్స్ మీదనే వస్తుంది,
అనుభవం అంతే.
సో ఇట్లా క్రాసింగ్ అయిపోయాక 15 రోజుల తర్వాత చెకింగ్ చేస్తారు, సక్సెస్ అయింది.